Okay, well, good morning. Welcome to the final round of the 55th annual Roger J. Traynor Moot Court Competition. I am Miriam Billington. I'm administrator of the Traynor, and this is how the session will work today. I'm going to turn over the proceedings to our esteemed bailiff, who will introduce our panel. And at the end of the argument, the justices will leave the meeting to confer offline. And then I'll come back with some thank yous and awards from the rounds from yesterday. Then the justices will return to court and provide their feedback and comments and announce the winner of this year's Traynor. Acting as our bailiff this morning is Professor David Glassman. He is a decades-long supporter of this competition. For the purposes of this session, David Glassman and I are not affiliated with either of these teams. I thank all of you for coming, and we now turn the proceeding over to the bailiff, Professor Glassman, who will introduce the justices.
Thank you, Miriam, and welcome to the final round of the 55th edition of the Roger Traynor Appellate Moot Court Competition. We congratulate both teams that have reached the final, as well as all teams and competitors that participated in the preliminary rounds, which consisted of both a separate brief writing component and oral argument evaluation that was conducted yesterday that determined today's finalists. The Traynor's wonderful reputation for so many years in the space of moot court competitions is in large part based on not only the quality of the presentations made, but of the judging done, and particularly in the final round. And today we're very pleased with the three bench officers that have agreed to preside over the final round. They are, first, Justice Terry Cody of the 2nd Appellate District. For those of you that are not as steeped in California appellate geography, Justice Cody's division of the Court of Appeal hears all Superior Court appeals from the counties of Ventura, Santa Barbara, and San Luis Obispo. We are also pleased to have Justice Martin Buchanan of the 4th Appellate District, who has agreed to sit with us as a judge in today's final round. Justice Buchanan is in the 4th Appellate District, as I mentioned, which hears essentially cases from the greater San Diego area and environs. Our third judge, whom we very much appreciate joining today and who has been a judge for us for many years of Traynor competitions, is Judge Matthew Guasco. Judge Guasco sits on the Superior Court of the County of Ventura. So we are represented by judges from a variety of places to hear our case today. We have two teams, as you know. Each team has a total of 30 minutes of argument to be divided amongst two participants. On the appellant side, one of those participants is entitled to rebuttal. So I will ask, once we have introductions of team members, that the appellant advocate who is presenting the rebuttal indicate prior to the argument that he or she is doing rebuttal and how much time they would like. So it will be 30 minutes divided by the two appellants, followed by 30 minutes from the respondent, and the final word will be from the appellant advocate who has reserved some of that 30 minutes of time. At that point, there will be a pause, and the judges will separately confer outside of this Zoom session for a few minutes, and then we will reconvene, and Ms. Billington will explain to us the results of this year's competition generally in terms of additional awards and recognition, and also identify the winning team from today's final. With that, I'm prepared to have the competitors today introduce themselves, unless anyone, competitor or judge, has any preliminary questions. And I will be keeping the time and displaying warnings about elapsing time to the participants. Any questions by anyone? I see no questions, so I will ask appellant's counsel to identify themselves and indicate who is doing rebuttal and for how much time.
Good morning, everybody. My name is Elise Wertman. I will be arguing for the appellant side first. Happy to be here. Good morning, everybody.
Thank you, Ms. Wertman.
Hi, everyone. Good morning. My name is Adriana Herrera. I will also be arguing for the appellant and reserving 2 minutes for rebuttal. Thank you.
Thank you, Ms. Herrera. Respondent.
Good morning. My name is Hannah Nguyen, and I will be arguing for respondent.
Thank you.
Good morning. My name is Winnie Ellerman. I'll take on the second issue for the respondent.
Thank you. Does anyone have any further questions or anything that needs to be addressed? Otherwise, we can proceed with the argument. All right, we'll begin. Counsel for appellant, Ms. Wertman, you may begin.
Good morning, Your Honors. May it please the court, my name is Elise Wertman, counsel for appellant, the City of Portola. The First Amendment right to free speech is one of the most fundamental rights under the United States Constitution, specifically the right to express individual beliefs and scrutinize the government. California Penal Code Section 148.6 impermissibly limits this right and restricts constitutionally protected speech. This law is completely at odds with the goal of protecting free speech, as it solely criminalizes speech that is critical of government actors. Today, appellant asks the court to reverse the lower court holding and invalidate Section 148.6. There are 4 issues.
It's Justice Buchanan. I was just wondering if you could clarify, is the city's position that both subdivisions A1 and subdivisions A2 of the statute are unconstitutional, or just subdivision A2?
Yes, Your Honor. It is the city's position that both are unconstitutional. I will let my co-counsel later address the constitutionality of Section 148.6. I will begin by addressing the first issue of standing today before the court. Turning to the first issue of standing, appellant has standing to bring this First Amendment challenge. Under the Singleton framework, as it has been applied by the California courts, appellant is considered a proper plaintiff to adjudicate this issue, and the court should proceed to address the merits of the case. Singleton versus Wolf was decided by the United States Supreme Court, and a modified version of the Singleton test has been adopted by the California appellate courts. Specifically, when cities and counties seek to assert fundamental constitutional rights on behalf of their citizens, the litigant is not required to show that they've suffered an injury. I want to direct the court to Selinger versus City Council and Sanchez versus City of Modesto, both appellate court holdings that applied this modified version of Singleton and held that a municipality is not required to show an injury. Instead, they used the Singleton test and focus solely on 1, the relationship and interests of the litigant and its citizens, and 2, the inability for those citizens to assert their own rights. An additional case that follows the same reasoning of Selinger, which is Central Delta Water Agency versus State Water Resources Control Board, also adopted this modified test, putting a specific emphasis on the interests and relationship of its parties. More specifically,
what are the limits of your standing argument? Does this mean that the city could assert that any state statute is unconstitutional on behalf of its citizens?
No, Your Honor, that is not the position that the city wishes to adopt or asks the court to adopt. Instead, this modified version of the test, while it doesn't require a specific injury to be shown by the municipality, there are still limits to this test. The city still must show that 1, its interests and the absent third-party interest are so aligned that they would be an effective proponent of their rights, and there must be a showing that there are genuine obstacles in the face of citizens mounting their own challenge to the section, thus making the city a proper plaintiff to present the issue.
And how are the city's interests aligned with its citizens' interests in this case? It seems to me the city is not asserting its own First Amendment rights, it's asserting somebody else's First Amendment rights.
Yes, Your Honor. The city today does not argue that the city itself possesses any First Amendment rights. In fact, Starkist Foods, Inc. versus County of Los Angeles makes clear that a city or county, as a creature of the state, has no individual rights of its own. However, California appellate courts have still allowed municipalities to assert fundamental individual rights in a variety of contexts when it found that the city would be an adequate plaintiff to adjudicate that issue. I want to direct the court to a well-established line of cases that has said when it's appropriate to confer standing in circumstances in which the enjoyment of a fundamental constitutional right is inextricably bound up with the city's duties. In Selinger versus City Council, as cited before, the court found that the city's duties, or rather that the local citizens' rights were bound up with the city's duty to review and condition subdivision approvals to assure appropriate land uses. That was a due process issue. In Central Delta Water Agency, citing the Selinger court, the court found that the equal protection rights of the agency's constituent water users were inextricably bound up with the agency's duty to supply water. This case mirrors and flows naturally from its predecessors in that the First Amendment rights of the citizens are bound up with the city's duty to accept and review complaints that citizens file against its peace officers. The city has a duty to establish a filing and investigation process under California Penal Code, Section 832.5. The
Counsel,
city does.
Isn't that simply a ministerial duty that the city has? And under Lockyer, the city would not have standing to assert the unconstitutionality of the statute?
Your Honor, because the city has a duty to accept complaints from its citizens, it also has a duty to assure that when citizens are filing those complaints, that they are able to fully and freely exercise their First Amendment rights. So following the reasoning of Selinger, the city's interests are bound up with the enjoyment of the citizens' First Amendment rights, thus making them a proper plaintiff in this case. I want to turn to the second prong of Singleton that I previously mentioned, was that citizens face a genuine obstacle in this case in seeking to mount their own challenge to Section 148.6, which is another reason why the city should be allowed to proceed with third-party standing.
But before you do that, can we go back to Justice Cody's question? Because I think she asked about Lockyer, and I'm not sure I heard you address Lockyer.
Your Honor, I won't lie. I'm not familiar with the holding of Lockyer today. I would be happy to submit supplemental briefing on the issue if the court would be so inclined to accept that.
Thank you. We'll let you know if we need that.
Thank you. Turning back to the final prong of Singleton, which is that there are genuine obstacles in play here that would prevent citizens from mounting their own challenge and risk future speech further being chilled by this statute. Section 148.6 prescribes misdemeanor punishment when it is violated. Misdemeanor punishment is considered a genuine obstacle. As we've seen in Stanistreet and Shaker, the two cases in which Section 148.6 was challenged, both of those cases involved defendants who were prosecuted under the section. While this isn't the only way that citizens could mount their own challenge, it is considered an obstacle since it is clearly the most common way that this section is going to be challenged in the future, and the court should refrain from forcing this issue to later be adjudicated in a criminal proceeding. I want to address a second obstacle that citizens face in mounting their own challenge. Sanchez versus City of Modesto addressed a similar obstacle, and the court found that third-party standing was appropriate because of it. In that instance, the law in question had not yet gone into effect, although it had been passed, and the court found that because it wasn't currently in effect, that citizens would find difficulty in finding someone to sue, and for what for if they hadn't suffered any concrete injury under it. Similarly here, the city hasn't enforced the signatory requirement since the consent decree has been in effect and later dismissed. That's been nearly 20 years since it's been in effect. Thus, how would citizens mount a challenge against the city to invalidate a provision that hasn't been implemented in over 20 years? It makes little sense to force citizens to wait until an injunction has been instated so that they could find somebody to sue and a concrete injury to raise. I want to also turn back to another principle as to why First Amendment challenges, the standing principles, are often relaxed. Also, First Amendment challenges are routinely adjudicated on behalf of those who, or rather on behalf of third parties. Specifically, the court in Garwin Farming versus Agricultural Relations Board addressed why these principles are relaxed and found that when there's a danger of chilling free speech, the concern that constitutional adjudication be avoided whenever possible may be significantly outweighed by society's interest in having that statute challenged. In this case, the danger of deterring and limiting speech that is critical of the government is a chilling effect that deserves the relaxation of these standing principles and for the court to address the merits today. I want to also point the court to the procedural history of this case. The lower court
sorry, but with regard to the chilling effect, didn't Stanistreet reject the idea that Section 148.6 has an impermissible chilling effect and actually say it's really no different than any other perjury law?
Your Honor, while Stanistreet did uphold the validity of Section 148.6, there is law out there, such as Shaker, that held that Section 148.6 was unconstitutional. I will let my co-counsel address those merits more thoroughly in a few moments, but I just want to point the court to the procedural history of this case, and that the lower court already granted the injunction and found no issue with regard to the city possessing standing, and thus standing should be appropriate today. If I see no further questions, I will conclude and say that the Singleton test indicates that the city is a proper plaintiff and should be granted third-party standing to litigate the constitutionality of Section 148.6. Thank you.
Thank you.
Ms. Herrera, you may proceed. You've asked for 13 minutes.
Good morning, and may it please the court. My name is Adriana Herrera, and I will be addressing the constitutionality and enforceability of Section 148.6 for the appellant, the City of Portola. I would like to reserve 2 minutes for rebuttal. The Police Protective League should be barred from enforcing Section 148.6 of the California Penal Code for 2 reasons. First, California law does not allow us to reach the merits of the case because California Civil Code Section 3369 bars the use of injunctions to enforce a penal code. Second, even if the court disregards the clear statutory instruction of Section 3369, Section 148.6 is an unconstitutional viewpoint restriction in violation of the First Amendment, burdening free speech by selectively criminalizing civilians within the complaint process while allowing all others to speak without restriction.
Counsel, I have a question, if I may, without taking it out of stride. Assume for the sake of argument that reasonable minds could agree that the legislation that produced this statute does in fact have the effect, a dampening effect on people feeling comfortable, especially in marginalized communities, to make complaints against the police. Just assume one were to agree with that. Hasn't our ability to reach that conclusion been foreclosed by the decision of the California Supreme Court in Stanistreet? Didn't they reach precisely this question? And aren't we restricted to simply following that precedent?
Your Honor, it is correct that Stanistreet addressed this exact issue, but this court is not bound by its ruling. The court in Stanistreet specifically found that Section 148.6 was constitutional using the RAV versus City of St. Paul analysis, which applies to speech unprotected by the First Amendment. Specifically, the court in Stanistreet noted that the content discrimination analysis required by the First Amendment applies differently in the context of proscribable speech than in the area of fully protected speech. In the time, however, since Stanistreet was decided in 2002, the Supreme Court decided in United States versus Alvarez that false speech is not granted, or false speech rather, is granted First Amendment protections. Accordingly, the logic that the court used in Stanistreet to find Section 148.6 constitutional is no longer good law, and this court is free to decide as it wishes.
Wouldn't that be more appropriate for the Supreme Court to do? The California Supreme Court, I mean, we're just an intermediate appellate court. Aren't we still bound by Stanistreet unless and until it says otherwise?
Your Honor, because the holding in Stanistreet is no longer good law because of United States versus Alvarez, this court is free to adjudicate this issue and find Section 148.6 to be invalid.
All right, Ms. Herrera, let's just say we disagree with you and we believe that we are bound by Stanistreet, notwithstanding Alvarez. Do you have any argument left?
Yes, Your Honor. And this brings me to my first issue, which is that section
No,
one.
before you get to the 3369 issue, let me just make sure I have an answer on the other issue. Assuming that we believe we are bound by Stanistreet, do you have any argument left on your second viewpoint discrimination issue?
Your Honor, section 148.6 is a viewpoint restriction as applied, even if we were to apply the framework within RAV, because it discriminates against specific parties within the complaint process, and that is the basis of the viewpoint restriction argument, and which can be applied successfully under RAV, as the Ninth Circuit did in Shaker v. Krogan in 2005. Turning now to my first issue, briefly, section 3369 of the California Civil Code specifies that injunctions cannot be used to enforce a penal law. Section 148.6 is a penal law. It is found within the Penal Code. Specifically, it is found within Part 1 of the Code, titled Of Crimes and Punishments, and within Title 7 of that part, titled Of Crimes Against Public Justice. Therefore,
Ms. Herrera, did you raise this argument in the trial court?
Your Honor, there was discussion of this in the trial briefs regarding section 3369.
All right, thank you.
Yes. Because section 148.6 is a penal law and specifically found within portions of the Penal Code which discuss crimes and punishments, it fits squarely under the holding or the language of section 3369, and injunctions cannot be used to enforce this penal law. However, even if the court finds that they have the power to issue an injunction in this case, they should not do so because section 148.6 is an unconstitutional viewpoint restriction in violation of the First Amendment. The Supreme Court in Iancu v. Bernetti in 2019 reinforced the concept that the government may not discriminate against speech based on the ideas or opinions it conveys. Here, the government does discriminate against speech, the speech of those making the complaints. Inherent to the idea or opinion conveyed in a complaint is a critical statement against the government or its officers. Here, section 148.6 criminalizes only the party who is making those critical comments against the government or its officers and leaves—
Counsel, does it make any difference though that the statute focuses specifically on knowingly false statements, which certainly there can't be any policy to promote or protect?
Certainly, Your Honor. While the statute does focus on the falsity of the statements, it is nonetheless a viewpoint-based restriction because it only provides the possibility of criminalization for the party making the complaint. There are other parties who do speak within the complaint process. The complainant will first make their complaint, and then the police officer is also offered the opportunity to respond to that complaint, and witnesses who may be party to the conduct also speak within the complaint process. And yet the only individual who is offered the possibility of criminal punishment for their speech, true or false, within the complaint process is the complainant themselves.
Isn't this exactly—
Sorry, go ahead, Ms. Cody.
Isn't this exactly the issue or the argument that Stanistreet addressed though, and found that yes, it is a viewpoint discriminatory statute, but it's a permissible discrimination because it results in formal investigation and record retention. And so there are consequences different from when somebody makes a false statement in the investigation.
Your Honor, I have two responses to that question. The first is that Stanistreet relies on a logic from RAV versus City of St. Paul, which specifically addresses unconstitutionally protected speech. In the ruling in United States versus Alvarez, the First Amendment has now been found to apply to false speech, and therefore the logic of the first exception of RAV is no longer applicable to this statute.
Well, didn't RAV, I thought RAV did say that proscribable speech is protected in the sense that you can't discriminate in a way that promotes one viewpoint over or certain content over another.
Your Honor, that is correct.
No, go ahead.
RAV does hold that even if speech is unprotected, it is entitled to some First Amendment protection. However, the court in Stanistreet specifically applied the content discrimination analysis differently because they wrote, and I quote, "It applies differently in the context of proscribable speech than in the area of fully protected speech. United States versus Alvarez makes false speech fully protected, and therefore that reasoning is no longer applicable here." I would like to turn to your second concern, which is that false speech made by the complainant is inherently more destructive to the integrity of the complaint process or police officers' careers. I would like to point the court to Officer Gordon's testimony. Officer Gordon served in the police force for 28 years and is currently the head of the Portola Police Protective League. He himself specified that he expected both witnesses and police officers to tell him the truth about the conduct within the investigative process, because if they lied, it would waste public resources and undermine the integrity of the investigative process. This is the record at 1043. It is clear that all speech within the complaint process could be equally as damaging to the police officer's reputation and careers, and therefore criminalizing only false speech by the complainant does not sufficiently address the government's compelling interest here.
Well, isn't there an important distinction, though, that was inherent in Officer Gordon's testimony between a witness who's being contacted during the investigative process and the initiator of the process itself? The witness isn't just somebody that the police are going to talk to unbidden. They're invited to do so by the filing of a complaint that has mandatory requirements to be investigated and retained, and becomes a blot, if it's false, knowingly false, on the officer's record for a very long period of time. Isn't there an important distinction there?
Your Honor, it is true that the complainant is the individual who initiates the complaint and the according proceedings. Nonetheless, all speech made within the complaint process, whether true or false, has the effect of damaging or withholding the investigative process's integrity, as stated by Officer Gordon. Telling him the truth during those investigations is just as important from police officers and from witnesses as it is from the complainant, because all false speech within the complaint process can delay the proceedings and affect the officer's career. However, even if this is a viewpoint restriction, the law could still be upheld if it withstands strict scrutiny. However, Section 148.6 fails. In order to withstand strict scrutiny, a law must be necessary and narrowly tailored to a compelling government interest. Here, I will address these issues in turn. First, as discussed, Section 148.6 is under-inclusive to the government's stated interest of public resources, efficient use, and the integrity of the investigative process. Because Section 148.6 only criminalizes those who are making the initial complaint, the law does not fully address all of the possibilities to which resources may be wasted and the integrity may be undermined within the complaint process from witnesses and from the police officers themselves.
Ms. Herrera, would your reasoning on the First Amendment issue also require us to invalidate Penal Code 148.5, which makes it a misdemeanor for anyone to falsely report a crime?
Your Honor, it would not, because specifically because of the language that it makes it illegal for anyone to file a false complaint. Here, Section 148.6 does not target all speakers within the complaint process. It only targets one party within the complaint process, and that is the basis of the viewpoint restriction.
But isn't that the same under 148.5? In other words, if I make a false report that my friend committed a crime, I'm subject to prosecution under 148.5. And then if my wife, during the course of that investigation, tells the police that I was lying and my friend was not committing a crime, assuming she's speaking falsely, she wouldn't be prosecuted.
Your Honor, within Section 148.6, the only individual within the complaint process who is targeted for false speech is the complainant, while all the other parties will still be speaking within the complaint process. If I'm understanding your point correctly, or your concern, Section 145 will criminalize anyone who is making an initial false statement to the police, and there is no inherent speech, secondary or following up that initial false filing. Here, other parties do speak within the complaint process, and the inefficiencies resulting from false speech would, I see that I'm out of time. May I briefly conclude?
Yes, you may, Ms. Herrera, go ahead.
All false speech within the complaint process would result in inefficiencies. Accordingly, we respectfully ask this court to adopt the reasoning of the Ninth Circuit and strike down section 148.6 as an unconstitutional viewpoint restriction in violation of the First Amendment. Thank you.
Thank you, Ms. Herrera.
Respondent may proceed. Counsel Lynn, you have 15 minutes.
Good morning, Your Honors, and may it please the court. My name is Hannah Nguyen, and I, along with my co-counsel, Winnie Ellerman, represent Appellee, the Portola Police Protective League in this matter. I will be discussing why the city does not have standing to appeal and why Penal Code 148.6 does not discriminate based on viewpoint. My co-counsel will be discussing why the same penal code does not create an impermissible burden and why reliance on Stanistreet was proper. This case is about false speech and how such misinformation causes public harm. The city's refusal to comply with this penal code poses a significant and intolerable risk of direct and severe consequences for police officers and the public. This court should affirm the lower court's decision for two reasons. First, the city does not have standing to appeal. And second, the penal code does not discriminate based on viewpoint, but even if it does, this statute is still constitutional. Turning to my first point, the city does not have standing to raise its constitutional arguments. Under the California Civil Code of Procedure 902, to have standing in California, a party must be aggrieved. In this case, the city lacks standing because they are not aggrieved. In Craig versus Boren in 1976, the United States Supreme Court stated that a party may only bring a third-party claim to raise the rights of others if they have been injuriously affected themselves.
Ms. Nguyen, let me ask you this. Couldn't the city rightfully claim that it's pretty aggrieved if the Ninth Circuit's told them not to do the thing that this injunction's forcing them to do? Isn't that enough beneficial interest to warrant standing for the city?
Yes, Your Honor. Even if this court finds that the city has standing to appeal this injunction based on the Ninth Circuit Court in Shaker versus Krogan in 2005, my second point will show why the city's claim lacks merit. Turning to my second point, the penal code is constitutional and it does not pose a viewpoint discrimination. This case requires the court to consider the reasoning behind the enactment of the penal code as well as the legislative intent. In 2002, the California Supreme Court in People versus Stanistreet found that this penal code was constitutional, underscoring the importance of protecting the public, protecting law enforcement officials, and protecting government resources.
But counsel, I understand that the reason for the statute was to promote confidence in police officers as well as the investigative process, but how is singling out a false report of misconduct any different from a false report of good behavior on behalf of a police officer? Doesn't that also undermine the reason why this statute was enacted in the first place, which was to promote confidence in peace officers?
Yes, Your Honor. However, before the enactment of this penal code, there was a rising tide of knowingly false complaints, as shown on page 20 of the record. The legislature decided to enact this penal code at issue to combat these knowingly false statements that causes harm to the public and to officers. So once a complaint is lodged against an officer, that officer is immediately removed from his unit. He's placed at a desk and he's no longer eligible for additional pay, which is a tangible economic loss. The officer additionally could lose promotional opportunities in the future. And this is why this penal code was enacted in the first place.
Ms. Nguyen, aren't the consequences of a false statement clearing a police officer just as pernicious, if not more? I mean, if we have a bad cop out there and people are lying on behalf of the bad cop, as a result of which the bad cop stays on the force, isn't that just as pernicious as a false statement that harms a cop's career?
Yes, Your Honor. While there may be harm to that, speech that is supportive of the government, that is knowingly false, does not rise to the level of harm that we have here. So, for example, if a statute were to reach pro-government speech as well as speech that's critical to the government, then we would have this issue of overbreadth, where we would punish a substantial amount of protected speech, and that is what the First Amendment seeks to protect. Additionally, under Stanistreet, the California Supreme Court found that this statute was constitutional. And
But wasn't Stanistreet considering an entirely different claim of viewpoint discrimination from what's being alleged here? The way I read Stanistreet, it was about complaints against peace officers versus complaints against other public employees. I didn't see anything where it addressed the viewpoint discrimination issue that we have here, which is false statements complaining about police versus false statements supporting police.
that is true, Your Honor. However, the Stanistreet Court was correct in finding that no viewpoint discrimination occurred at all. Additionally, the Stanistreet's analysis of this penal code was correct, and for two reasons. First, this admonition applies equally to all individuals, regardless of their viewpoint. And second, when the law only restricts calculated falsehood, such regulation is permissible under the First Amendment. And here, this penal code does not suppress speech. It merely warns people of the consequences of filing a knowingly false complaint. The Constitution does not require us to tolerate knowingly false statements, especially if they cause harm. And if we look to the purpose of the enactment of this penal code, as shown on page 20 of the record, in the Portola County Sheriff's Office alone, 500 complaints were filed, and of those 500 complaints, 60 to 70% of those complaints were false. Additionally, on page 21 of the record, gang members have been known to file these knowingly false complaints to have officers kicked off of their units. And again, on page 22 of the record, false complaints have also been exploited by attorneys to gain free administrative investigation and discovery.
Well, let me ask you, Ms. Nguyen, what effect, if any, does the Supreme Court's decision in Alvarez have on the sort of categorically broad statement you've made that the First Amendment doesn't protect falsehood?
Your Honor, under the United States Supreme Court in United States versus Alvarez in 2012, the court held that false statements are protected under the First Amendment if they're considered as mere puffery. But that is not what we have here. What we have is a statement that causes public harm. So the takeaway from Alvarez is that falsity alone is not enough to bring the speech outside of the First Amendment. However, if that falsity is made with an intent to harm or with some level of recklessness, the First Amendment would not extend that far. And this is what we have here. This penal code only restricts knowingly false statements that causes harm. Let's say if this admonition was not required, we will have this issue of unethical citizens who can come forward to file a knowingly false complaint to simply kick an officer off of his or her unit, and that should not be allowed.
Well, going back to Justice Buchanan's distinction between a knowingly false complaint against an officer compared and contrasted with a knowingly false witness statement by another officer supporting misconduct. In the one instance, the complainant is penalized, potentially criminally. In the other instance, there's no such penalty. Isn't that a pernicious thing that undermines your protection argument under RAF?
Yes, Your Honor. Well, that may be true. However, if this statute were to also reach pro-government speech, then we would have this issue of suppressing too much protected speech. If the legislature wanted to enact an additional penal code to limit this, then that would be allowed. However, what we're looking at is this penal code at issue. And this one specifically was enacted to combat all of these knowingly false statements that were filed against police officers.
Ms. Nguyen, aren't we particularly concerned under the First Amendment with laws that single out anti-government speech?
We are, Your Honor. However, laws such as defamation or fraud or even perjury has been permissible for the government to regulate. Courts have applied different legal standards to different types of speech, and often knowingly false statements are not protected in the same way as general criticism of speech against the government. Additionally, this statute only prohibits unprotected speech. As Your Honor mentioned, historically, speech criticizing the government and government officials receives the highest protection under the First Amendment. However, this protection does not extend to all speech as held by the United States Supreme Court in New York Times versus Sullivan in 1964. For example, in Stanistreet, the court looked at this statute and compared it to defamation. The court stated that this statute has a more stringent test than defamation itself because defamation only requires an element of intent that is reckless, whereas here, a person has to know. They have to come forward and knowingly file a false claim. So if a citizen comes forward and makes a mistake, this statute would not criminalize them and they would not be subject to criminal prosecution. Your Honors, to further prove that this penal code is constitutional, the California Supreme Court in Stanistreet applied the RAV exception. In 1992, the United States Supreme Court listed 3 exceptions for when the government can further regulate the content of unprotected speech. And here, our focus is on the 3rd exception. The 3rd exception speaks to whether or not there is a suppression of ideas, and here, there is none. This exception implicates whether false statements of facts may be an idea, and as the Stanistreet Court stated, lies are not an idea. And specifically in this context, a person who comes forward to file a knowingly false report, they know that they came forward with this false lie. It's not an idea that would be protected under the First Amendment.
So counsel, do you really believe that that this will not suppress valid complaints of people who are concerned that they will be accused of knowingly filing a false complaint and criminally prosecuted? And I think that was the concurring opinion by Justice Werdiger. What's your response to her concern and her disagreement with that 3rd RAV factor?
That is true, Your Honor. While this speech may have the effect of some sort of chilling, however, defamation, for example, has that same effect, and the government is allowed to regulate speech that causes harm if it includes some elements of falsity. In Stanistreet, the majority stated that false complaints, lies, are not an idea, and that is our position here. Protected ideas would be more of something of an opinion. So for example, that officer was a bad officer, or that officer did a bad job. That would be an opinion that would be protected under the First Amendment.
The counsel, going back to Justice Cody's question, Justice Cody's asking, wouldn't under the 3rd factor, the 3rd RAV factor, wouldn't that argument that this would comply with that be undermined by the fact that, for example, a citizen who wants to file a complaint against an officer for fabricating evidence, for lying, might be afraid that that very same officer or the officer's colleagues would fabricate a knowingly charged complaint claim against that citizen, thus causing the citizen to stand back and say, I don't want to risk being punished for telling them the truth. Wouldn't it have that effect?
Yes, Your Honor. I believe what you're speaking to is the chilling effect that it would have on citizens to come forward to file. And while this law may have that effect, this law is no different than statutes such as perjury, where a person can come forward to under oath to, they read the same sort of admonition. This penal code is no different. It is the responsibility of our government to enact legislation aimed at addressing social harms caused by false speech. The objective is to not suppress speech, but rather to mitigate harms resulting from knowingly false statements. Under the First Amendment, speech such as perjury, defamation, and even fraud includes knowingly false statements that causes harm and has been permissible for the government to regulate. And there is no difference in the knowingly false statements under this penal code. For
I guess the difference in my mind between general statutes like perjury or general common law principles like defamation is that they don't single out a particular type of speech that is critical of the government. And this statute does seem to single out a particular type of speech that's critical of the government and put the complainer at risk of feeling that they might be retaliated against by those very same government actors for making a complaint. And that seems to me very different from defamation or perjury.
Your Honor, I see that my time has ended. Can I briefly answer your question?
Yes, go ahead.
Your Honor, for example, defamation, even though it doesn't single out a speech or one viewpoint over another, the level of intent under these statutes not only includes an element of falsity, but it also includes some type of harm. And that is what we have here under this penal code. Thank you.
Thank you.
Council Ellerman, you have 15 minutes.
Good morning, Good morning, Your Honors. May it please the court. Hopefully there's no more technical issue. Hopefully you can hear me. Great. My name is Winnie Ellerman, attorney for the Portola Police Protective League. Your Honors, this case is about the necessary balance between free speech and government regulation. As my colleague pointed out, free speech does not mean free rein to make statements that are knowingly false and harmful without consequence. And the government can restrict, and just as the government can restrict defamation and fraud, it can also prohibit an individual from making a false misconduct complaint against a police officer without running afoul of the First Amendment. The lower court's decision should be affirmed for two reasons. First, Penal Code 148.6 does not place an impermissible burden on speech because it does not run the risk of chilling an individual's right to speak out against the government in filing a misconduct complaint. And second, the California Supreme Court considered this exact penal code at issue in People versus Stanistreet and held that it was constitutional. Because this court is bound by Stanistreet, the lower court's decision should be affirmed. Before turning to my first point, I'd like to address an issue that was brought up by opposing counsel, which stated that Penal Code 148.6 was completely at odds with the First Amendment, but there are necessary and well-established limitations on free speech under the First Amendment, such as defamation and fraud. And as the Stanistreet court found, and as the Alvarez court found, knowingly false statements that lead to harm fall within one of these categories that can be regulated by the government without running afoul of the First Amendment.
Let me interject if I may with a question. Stanistreet obviously is the strong foundation of your argument, a decision we're required to follow. But don't we have a materially different circumstance here that the Stanistreet court didn't have? And that is the decisions in Alvarez and the orders and decision in Shaker. And what role should that play in what we do?
Your Honor, I think a strong consideration here is the binding effect of both of those decisions. First, we are of course bound by, or this court is of course bound by U.S. Supreme Court's decision in United States versus Alvarez, as well as the California Supreme Court's decision in Stanistreet. While the Shaker court, as a federal court on the issue of federal question, may lend some persuasive authority, it is not binding on this court. So while we could consider Shaker in this context, this court is not bound by it.
Well, then let me ask you, from a practical point of view, on the theory that all things courts decide are not devoid of whatever their practical reality or implications are, what's the city of Portola to do? On one side, it has Stanistreet. On the other side, it has an order, the effect of which is an injunction from the Ninth Circuit. What's the municipality to do?
Well, the municipality is bound by the court in California versus Stanistreet, and if the Supreme Court would like to take into account the Shaker decision in overturning People versus Stanistreet, it can do that, but it is not under this court's jurisdiction to be able to overturn the Supreme Court. In terms of how this
Well, if we were to find that the California Supreme Court's decision in Stanistreet is not reconcilable with the U.S. Supreme Court subsequent decision in Alvarez, would we still be required to follow Stanistreet?
No, Your Honor, you wouldn't be required to follow Stanistreet if you found that Alvarez was the more appropriate standard and it overruled Stanistreet. However, it's not our position that it does so. Alvarez
Well, why not? Why doesn't it?
Alvarez is distinguishable from Stanistreet specifically because Alvarez only held that false statements are protected under the First Amendment. In Alvarez, the court specifically considered that or recognized that speech like defamation and fraud fall within a category of speech that's prescribable under the First Amendment, that the government can restrict without running afoul of free speech. However, here, and in Alvarez, the court found, as my colleague pointed out, that that it only considered mere puffery, false statements in light of bragging or in light of using false statements for clout in a social setting, or in the setting of Alvarez, where he was in the setting of a water board meeting. However, here, there is real harm when there's when someone files a knowingly false complaint. From the record at page 21, false complaints filed against police officers adversely affect their participation in promotional opportunities. It restricts their assignments from field duties, and it impairs their possibility to gain overtime compensation, which is—
I don't think, counsel, I don't think any of us have any misunderstanding about the harm that false allegations of misconduct cause. The real question is whether it's permissible to single out those types of false statements, because as we pointed out with your colleague, false statements clearing a police officer who should have been found guilty of misconduct are equally harmful. And yet this statute has singled out one particular type of false statement. If you could address that, I'd appreciate it.
Yes, Your Honor, that's the issue of viewpoint discrimination, where a particular viewpoint cannot be protected in lieu of other viewpoints. However, in this circumstance, someone who files a misconduct complaint, in the context of a police misconduct complaint, if someone files a complaint that is disfavorable towards officers, they are just as liable for it is just as punishable as someone who were to file a misconduct complaint that favored officers. I'll admit it's probably uncommon that someone would file a misconduct complaint that was laudatory of officers. However, they are free to do so if they are free to do so in that context, and if they file a knowingly false complaint, they will be held to the same standard regardless of what the content of that knowingly false statement was, whether it was in praise of the officer or against the officer. Because as the court in Stanistreet found, because the viewpoint discrimination, or because the context of a police misconduct complaint triggers this automatic investigation that leads to the use of valuable public resources, then the government can prohibit those knowingly false statements without running afoul of the First Amendment. Your Honors, even if
Just a question. and I think it's been raised by both of my colleagues, but Stanistreet didn't address the exact argument that the city is making here. And therefore, anything they may have stated to support their ruling that wasn't directly relevant to the issue they were addressing would be dicta. So are we bound to follow dicta in a Supreme Court, even a Supreme Court decision, especially when we've got a Ninth Circuit opinion to the contrary that does address the precise issue that the city is raising?
No, Your Honor, this court is not bound to follow dicta in the opinion. However, because the Stanistreet court did consider viewpoint discrimination, it's not completely a different ground of unconstitutionality that is considered in the Shaker court. Although the Shaker court found a different viewpoint discrimination at issue than Stanistreet, the Stanistreet still considered viewpoint discrimination and found that that this penal code was still constitutional.
Can you explain to me why you think the Ninth Circuit and Shaker didn't address the 3 RAV exceptions that the Supreme Court in Stanistreet relied on? Doesn't that undermine the persuasiveness of the opinion in Shaker?
Your Honor, while the court in Shaker didn't address the RAV exceptions, they found ultimately the most binding precedent on this court for this particular issue is Stanistreet. And although Shaker does have persuasive authority, Stanistreet is directly on point, and the court found that this creates or that this penal code is presents a permissible, a constitutional restriction on speech. Turning to the issue of chilling speech, as Justice Guasco pointed out, Stanistreet did consider chilling speech. And the issue with the concern around chilling speech is that, as Justice Buchanan mentioned, the First Amendment seeks to protect especially false statements against the government. That is it holds the highest rung in protection under the First Amendment. And the concern around chilling speech would be that any penal code that threatens a misdemeanor for a false statement might stop someone from engaging in that speech that is so critical to the free expression of ideas. However, the penal code here does not place that impermissible burden on speech. In Reno versus ACLU in 1997, the Supreme Court considered the Communications Decency Act, which made it a crime for anyone to engage in speech that was indecent or patently offensive on a computer network that could be accessed by a minor. Because the terms indecent and patently offensive are subjective determinations, the court found that the Communications Decency Act would chill a person from engaging in speech because of a threat of criminal liability for engaging in that speech because of the subjectivity of the words indecent and patently offensive. However, here, unlike Reno versus ACLU, the penal code is restricted only to knowingly false statements, where the term knowingly is an objective determination. Someone either knows something or they don't know something. And this requirement of knowledge protects witnesses who honestly misperceive facts, and it insulates everyone other than those who specifically know that they are lying in the context of the police misconduct complaint. And because it insulates other people from prosecution under this penal code, the penal code does not threaten chilling speech. Your Honors, even if this court determines that Alvarez is the applicable standard, this penal code still is constitutional because it survives intermediate scrutiny. In Justice Breyer's concurring opinion in Alvarez, he applied the intermediate scrutiny standard, which weighed the importance of the law's objectives and the extent to which they meet those objectives, alongside the seriousness of the speech-related harm that the law will likely cause. The importance of the law's objectives here are to combat this rising tide from the record at page 21 of misuse of the complaint process by gang members and by personal injury attorneys who are trying to obtain free administrative investigation. And it can do so because weighed against the seriousness of the speech-related harm, the harm does not rise to the level where that would be unconstitutional. It still survives intermediate scrutiny. Your Honors, the free speech is not free rein to engage in any speech without consequence. And just as the government can prohibit defamation, fraud, and even perjury, it can also prohibit people from making knowingly false statements that lead to harm. This penal code does just that by prohibiting citizens from coming forward with knowingly false complaints of police misconduct that have significant negative consequences for peace officers. And it does so without chilling speech. Penal Code 148.6 is therefore constitutional, and the Superior Court's decision should be affirmed. Thank you.
Thank you, counsel. Counsel Herrera, you have 2 minutes of rebuttal.
Thank you. I have 2 points on rebuttal. First, opposing counsel is correct. This statute, or the government, can permissibly regulate false speech without running afoul of the First Amendment. It simply cannot do so under Section 148.6. First, I will address the chilling effects concern that opposing counsel raised, specifically that it is not relevant here because of similar laws regarding perjury or defamation. Those laws, as Justice Buchanan correctly pointed out, apply neutrally to all parties. Therefore, they do not run afoul of the First Amendment because there is no viewpoint discrimination concern. Here, Section 148.6 specifically targets one party within the complaint process and therefore is an impermissible viewpoint in violation of the First Amendment. Secondly, I would like to address opposing counsel's concerns about the legislative history of 148.6. Section 148.6 was first passed in 1995. It was passed then to address a perceived rising tide in false complaints against police officers, but we have much more recent information regarding whether or not those complaints actually exist. Officer Gordon noted in 2018, 3,189 complaints were filed, yet only 2 officers were demoted. This is the record at 977. Officer Gordon was not aware of any officer who was denied a promotional opportunity because he had a demonstrably false complaint on his record. This is the record at 983. Further, he did not know whether any gang members used the process to target officers in 2019. This is the record at 985. Finally, he also noted that a demonstrably false complaint would not prevent an officer from moving to a specialized unit, transferring between divisions, or working overtime. This is the record at 1033. Lastly, Officer Gordon himself had 23 complaints filed against him, and 0 were found to be demonstrably false. I see that I'm out of time. May I briefly conclude?
Yes, please.
Accordingly, Section 148.6 is not necessary to the stated compelling government interest. Therefore, it fails strict scrutiny and is unconstitutional under the First Amendment. We respectfully ask this court to adopt the reasoning in the Ninth Circuit and invalidate Section 148.6. Thank you.
Thank you, counsel. Mr. Glassman, what comes next?
That concludes the oral argument. Thank you to all the competitors. We will now pause for approximately 10 minutes and reconvene at approximately 11:15.
Great, thank you. So the justices and the bailiff are going to leave the courtroom to confer and to conduct the seemingly impossible work of choosing who prevailed in that remarkably great argument. Justice Guasco, if you could turn off your camera and mic and join your colleagues on the call. Yes, thank you so much. Okay, we have about 10 minutes. I want to thank everyone for coming to this morning's session. And I wanted to do some thank yous before I announce some awards. Yesterday on Saturday, we hosted 23 competitors total, I believe, 16 judges, and many, many observers from all over the state and even some outside of the state for 2 exciting rounds of oral argument. It all took place virtually on Zoom. As much as we really loved experiencing the Traynor in person before 2020, we have learned and seen that doing the Traynor virtually has greatly improved. One second. Thank you. The affordability and the accessibility and the inclusivity of the competition. And so we have continued to do it this way because people are able to do it and participate. And a huge part of that success this weekend was due to our host school. So we want to thank the University of West Los Angeles School of Law. Robert Brown is the president, Jay Frickberg, provost and dean, Jesse Aldava, Mauricio Caña, Chris Kutka, and Hamid Taf. They all helped us work to run the competition, both virtually and on site. Thank you to our able and dedicated student bailiffs. Some of them are here today. They took a break from studying for final exams to help us run the competition, and they were on site on the campus of UWLA. And we thank them for coming and running the courtrooms for us. Thank you to all our judges, some of whom are here today, who volunteered their time and energy and their expertise to this event. The whole competition is made possible by a generous grant from the Gisnet Mandel Moot Court Trust. Special thanks to Patrick and Ingela Pigot for making that possible. And just to let you know that we do have a competition program, which contains all the information you need about this year's competition, synopsis of the case, information about the trainer, and all the participants are all in the program. And that will be found on our website later today, maybe this evening. We'll have the program up there. We'll have the list of winners up there. And also that's the place to go for watching today's final. We will have a link up to see that as well. And that's all at traynormootcourt.org. If you'd like to sign up for next year's competition, you can do that too. Reserve your spot. So for the awards, the justices are conferring now, and they will announce the winner of the Roger J. Traynor Award, which is the winner from today's argument. But we have awards won before today, including, first of all, the Gisnet Mandel Award, which goes to the best brief, which is graded separately from the oral argument. And the winner of that award is Berkeley. Berkeley had the best brief. Second place in the brief competition was achieved by McGeorge. And third place, Kern County. And fourth place, UCLA. So congratulations to the winning briefs. Next, we have Excellence in Appellate Advocacy. And that is the award that goes to the team with the highest combined total points, brief plus Saturday oral argument. And the winner of that award is Berkeley. And the second place for that award is McGeorge. And next we have the Jeffrey Hall Wright Award for Best Oralist. Jeffrey Hall Wright is profiled in the competition program. So please read about Mr. Wright, and we have named the award for him. This is the award for the best, highest score from Saturday's competition. And the winner of the Jeffrey Hall Wright Award this year is, and I believe I saw her in the courtroom today observing, the winner is Kathleen Cuschieri from Empire. Congratulations. The individual merit awards for oral argument go to Lillian Dutcher from Empire, Adriana Herrera from Berkeley, Jordan Hefcart from Berkeley, John Young from UCLA, Peter Hanna from UWLA, Alina Worth from Davis, Hannah Nguyen from McGeorge, and Adi Nair from UC Law San Francisco. Congratulations to everyone who won an award, and we will return in about 5 minutes with the justices who will be announcing the winner of today's argument. Again, thank you all for coming, and we'll see you in about 5 minutes. Okay, I see our 3 justices, our 4 finalists. Thank you all, and take it away, Presiding Justice Cody.
Well, I was extremely impressed with everybody's presentations. I said this many times already. This was a very difficult assignment, I think, for all of you. And I really felt like you handled the cases well. I thought you responded very well to the Alvarez argument, distinguishing it. And I think the appellate side, you responded very well to all the questions that were asked, and then didn't allow you to get off track. So I thought, again, both sides did an excellent job. We'll see. Justice Buchanan, how about you?
Yeah, I mean, I agree. Justice Cody, I think it was a really tough issue for law school moot court, and more complicated than most cases that we see here at the Court of Appeal. I will say I wish that all of the counsel who appeared in front of us at the Court of Appeal were as well prepared as each and every one of you. You were all completely well prepared and had everything at your fingertips. And sincerely, like, we don't see arguments like that very often in real life where the attorneys are so well prepared. So that was just wonderful. I'll just give a few, I mean, just saying, I thought all of you did a fabulous job. I'll just give a few little individual comments, and these will all be on the constructive criticism side, because I've already given you my global praise, which I sincerely mean. Let's see, Ms. Wertman, I think you got a little bit, when Justice Cody asked that question about ministerial duty and Lockyer, and then I asked the follow-up question, you know, obviously Lockyer was not something you were familiar with. That's perfectly fine, happens in oral argument all the time. I guess if I had been in your shoes, I would have just said right away when Justice Cody asked the question that you weren't familiar with Lockyer, and then answered the ministerial duty question as best you could. But perfectly understandable, not a horrible mistake or anything. Ms. Herrera, let's see. I would say, the one thing I would say about your presentation is I thought that maybe you put a little too many eggs in the Alvarez basket. Because when I tried to really push you, and I know it was a little unfair how hard I pushed you about assuming that we think that, what I can't even remember my question, but, you know, would you still have a viewpoint discrimination argument left? I think you were just stuck on Alvarez, and there was another way where you could have said, well, Stanistreet addressed a different viewpoint discrimination issue. I will say, I thought your rebuttal was excellent, and maybe it's only because you invoked me by name, which justices love. Anyway, let's see, Ms. Nguyen, I felt on, let's see, when Justice Guasco asked you about a question about standing, I felt like you pivoted immediately to the merits, without directly responding to his question on standing. And I thought that was an instance where even if you didn't want to spend a whole lot of time on standing, which I completely understand, and that was the right call not to, I think, still I would have had some short answer to that question and then pivoted to the merit. And then finally, Ms. Ellerman, at the beginning, this happens with real lawyers all the time. Justice Guasco was trying to ask you a question and I think you didn't hear him. This happens very often with remote arguments in our court where the lawyers just simply do not hear or they can't see us. So just, kind of a heads up, you got to really be on your toes, make sure you're listening for the questions. I tried to ask you softball, which is kind of like a question that favors your position and maybe I didn't phrase it the way I should have, but I was trying to, when I tried to ask about Chaker's failure to consider the 3 RAV exceptions, I meant for you to embrace that and say, yes, right, that's why Chaker is wrong and Stanistreet is right. And I felt like maybe you didn't embrace my question quite as much as I hoped you would. Again, all 4 of you did fantastic. I just wanted to give some little constructive criticism as to each. Very great job. Justice Guasco?
Well, I want to echo what Justice Cody and Justice Buchanan, sorry about that, Justice Buchanan said. The presentations really were outstanding. Having practiced both in the Court of Appeal as well as now being a trial judge, I have to echo what both the justices said. It really is inspiring to me and makes me hopeful that when you graduate, you're going to have several steps ahead of many of the other lawyers with whom you'll work, given how elegant and wonderful these presentations were. You were very well prepared. I was very impressed with your facility with the records in your cases, and also with the details of the precedents that you were going to be arguing. That's not easy. There's a lot of preparation that goes into that, and you weren't reading from something doing that. That was just something that came to mind. I actually thought, Ms. Ellerman, that was your strong suit. You were able to draw some of the precedent details to mind very, very quickly. Something that I think everybody experienced at one point or other, because every lawyer does, no matter how experienced you are, you can get stymied by questions. And I remember the wisdom of my mentor. Justice Cody remembers my mentor, who was the late Ed Lasher, who was actually one of the creators of the appellate specialty in California. And he was my father-in-law as well. He taught me a lot of things, but one of them was every question you get from a trial judge or a justice, no matter how it's packaged, no matter how hostile it might seem, is an opportunity. It's an opportunity for you to share your client's point of view, your perspective about the issue. And when you look at it that way, it takes a lot of the nervousness out of it, right? It stops you from overanalyzing it, which is, I think, sometimes where the delay and the nerves start setting in, is when you're overthinking the question, like the softball that Justice Buchanan was serving. A lot of those questions are friendly questions. They might not seem like it, but they really are. And oftentimes they're the way the justices communicate with one another to get something fleshed out. I empathize for the appellant in this equation. When you draw the appellant side of this, boy, do you have a steep mountain to climb, because you're basically saying we want a subordinate court to not follow the Supreme Court. And that's never easy to do, but I thought you handled it really, really well. Well done, everybody. I was really impressed.
And I echo everything everybody said. They were a little more detailed in their comments, but I thought both sides did a very good job for the most part of getting back on track even after the questions. I know you have sometimes that can throw you off, and sometimes it should throw you off, the questions that are asked. And I would encourage you too, Judge Wasco, I think, said it, but I'll say it differently. Not only are the questions an opportunity to shine, but to really listen to the questions. Don't treat them as an interruption in your presentation, but was actually an inquiry. Like, let's have a dialogue. Let's talk about this issue. And I think most of you, for the most part, did a very good job with that, because when I ask a question on the bench, I want to know the answer. I enjoy having a dialogue with attorneys on an issue that I may not feel confident about. I want to know what your answer is, and let's talk about it. So I thought you all did a pretty good job with that, but I know it's nerve-wracking and hard because you're trying to cover all the issues that you need to cover. So again, I was very impressed with both teams, but we have to choose a winner. And so the three of us have discussed, and we have come up with who we think should be bestowed with that honor. And we have decided that it is the team of Ms. Wortman and Ms. Herrera, the appellants. So congratulations. Again, you all did such an amazing job, but we had to choose, and we think that you really shine today.
Thank you all so much for your time judging. Yeah, this was a great experience, so thank you all.
Thank you as well for your feedback. We really appreciate it.
Do the competitors have any questions for the justices? Well, congratulations to Berkeley, Team 4, and congratulations also to McGeorge, Team 1. Both teams were incredible, as the justices just communicated to you. And congratulations to everyone who competed in the Traynor this year. And this evening, please check the website for all the list of winners. And thank you, everybody, for participating, for judging, for observing, for making time for this really important and historic competition. I wish you all a wonderful rest of your weekend. Thank you so much, and I hope to see you next year. Thank you, Professor Glassman, and thank you all.
Wow. You're kidding.